when I was at the patent office, someone in my art unit, someone came in with a method of cutting hair.
Okay.
Now understand, they have to give you a patent if they can't find prior art. But some things are so far out there, even though it makes like, I know how to do this, there's just nothing written about it because no one thought it was important enough to write about or exploit or anything like this. And I think it got allowed, and then there was an uproar. The office pulled it back, and they eventually had to use Edward Scissorhands as prior art to invalidate the patent.
Let's go!
Hey, what's up, everybody? Welcome back to another episode of the Liquid Launch Project. I am Matthew R. Meehan alongside my partner, the professor, Luigi Rosa Bianca. What's on tap today, Lu?
Matt, I've had this doubt in my brain for decades on what on earth is the difference between a patent and a copyright and a trademark and where they overlap. And finally, I'm scratching this itch. So today on the podcast, we've got Austin Bonderer. Man, and I got to tell you, this guy's resume is pages long. He is the founder and head of the law offices of Austin Bonderer, and this is all they do, intellectual property. So Austin, welcome to the podcast. And please share with us the plethora of knowledge. What on earth is a patent?
Oh, it's a government-granted monopoly.
Oh, cool. Kind of like Major League Baseball.
Exactly. Yeah, it's a special little thing that comes in. It's actually a constitutional granted right. And you have the forefathers realized that the more patents they gave out, the faster we would improve our society. And that's pretty much why they granted.
Okay, so I could understand the marketability of a patent, right? If you come up with something cool and new and useful, you should be able to market that. So you have to protect that patent. But before we even get to that point, what is patentable? I don't even know is that a word?
Yes, it's actually the word. They got some weird words in patent stuff. So, so something is patentable if it has utility. So it has to have some kind of use. The other thing has got to be novel, which is new. Like it means that something exactly out like it cannot be out there. And then the last one, the hardest one, is unobvious. So basically, your product or your idea cannot be just an obvious combination of known items.
Okay, so you're obviously the smartest guy in this room. So can you give us an example of each so that the audience will sort of apply that to their daily life?
Yeah, I mean, it's kind of hard to find something that's not useful in some sort of way, but there are things. Probably, and then another one, it has to be concrete because one of the big issues we're having right now is abstract ideas. Software is not a physical item, so you can't really patent it except for in extreme circumstances.
Okay.
The new and novel just means like you can't just go out and copy the exact same item that's already out there. So you can't get a patent on something that's known. Now, the unobvious standard or the obviousness standard just means that you have to have a true inventive step in what you're doing that the patent examiners can't find or make an argument that merely the change that you've made in view of what's already been out there and your added piece is obvious in view of something else. So in other words, what the patent office will do is they'll take two references. They'll say like A and B is found here, C is found over here, and we'll just add those together and say it's obvious to do so for one of skill in the art.
So basically, I can't go out and have a cup and then add a handle to a cup and say the cup with a handle is a new invention.
Right, exactly. Those little things, because it would have been, I mean, granted, say there was no such thing as a mug and you did that.
Yeah.
It would have been obvious to put a handle on it because people hold cups. Therefore, it would have been obvious to add a handle to a cup.
Okay. And then now what's the difference between a patent and a trademark?
So trademarks are actually pretty interesting. So patents are timely. Like if you have a new idea, new invention, you need to get to the patent office right away because it protects the invention. And what you're trying to do is move science forward. And by doing that, you disclose these things. But the the office wants you, or the government wants you to do that as fast as possible, because the more advances we have as a society, the better off we are. Now, trademarks are different. Trademarks are there to protect the consumer by identifying a source of goods. I don't know if y'all saw Coming to America and McDowell's. That was the one
Yeah.
I was looked at. And McDonald's was always yelling at them, like, you're diverting customers to your store because they think it's McDonald's.
Okay.
So the trademark is actually there to protect the public, identify source of goods, even though it's very beneficial to a company to have a valuable trademark. And, like I said, it's not as timely. I even had a client that was in business for over 60 years decided to register their trademark. Now, there are a little different. One thing that people need to know is, as soon as you put a good on the market and it has a name or a logo, you have a trademark already. What we do is we register it with the federal government, and that ends up giving you a lot of benefits when it comes to enforcing your trademark throughout the country. Otherwise, you might just have a geographical protection. So in other words, sorry.
I have a question here for you. Okay, so let's say I open up, we'll use our company, Shield Advisory Group, right?
Okay.
Shield Advisory Group is our entity that we opened up. There's another Shield Advisory Group in, let's say, California, right? How do we go against protecting the name? Do we have to have trademarked that name in order for them not to use it?
Well, now you're in this little, like, who was first?
Hmm.
You might have a geographical issue. Like, say, I assume, are you guys on the East Coast?
Yeah, we're on the East Coast.
Yeah, exactly. So this is what happens in common law trademarks. And this is why you really kind of want to get to the registration first. So
Okay.
they may say, hey, we've been developing some goodwill over here on the West Coast. We're not influencing any of your customers. There's no likelihood of confusion. Or you're moving into their market now, you see, and this is where the registration comes and kind of solves that issue, because the one owner owns it all. But if you're relying on common law, then you might have an issue of geographic. You're only allowed to use it in these areas because they have those areas. And then,
Now, if you register yours, then they're not allowed to use it at all. Whoever registers first, is that what I'm getting here?
yes, but it's also
Okay.
like first in use. So you can register a trademark, and then it could go through all the process, and then someone later on could say, well, we're going to contest that now. So even if you're registered the trademark, that's not the end all be all. So
Okay.
it's pretty much first in use always wins is the general rule. Obviously, everything has exceptions in law. So that's kind of what you're working with. So if you wanted to go and discuss with these people, they might predate you, and you might be the loser on the, at the end.
So, Austin, how about a unique scenario where, let's say there is a Shield Advisory Group in Montana, but they actually make shields for Halloween, right? Halloween and theatrical purposes, okay?
Yeah.
And they say, well, Matt, get your big lawyers from Wall Street out of here. We just make little shields. We don't do consulting. We don't help small business owners. There's no confusion here. We actually just make Halloween shields. Does that argument hold muster, or?
Oh, it totally does. I mean, you might, just take a generic name. Like you might have Acme Jewelry and
Sure.
Acme Oil Company. Since there's no likelihood of confusion, people aren't going to associate a jewelry company with an oil company. I mean, like Halliburton, they're all over the place. But
Yeah.
you understand what I'm saying, that generally
Of course.
it's all about likelihood of confusion.
Okay.
Okay.
That's
Now,
the main thing.
what about, I remember 20 years ago, I'm showing my age, Paris Hilton came out and she trademarked a catchphrase. That's hot. I have a friend that actually trademarked "Who's Your Daddy" as a catchphrase. How does that happen?
Well, I mean, the thing is, they have to put it on some kind of merchandise or something that they're
Okay.
selling. It's got to be a service or something. You have to be selling products with these names or the name of
Yeah,
the company, those kind of
he
things.
had it on an energy drink. It's called "Who's Your
Yeah,
Daddy?"
exactly.
The energy
So,
drink. Yeah.
Okay, so that logo got milk. That's protected, right? We can't go out there and say, I've got almond milk, right? Because they've protected that.
that's correct. The issue with if they have a trademark on it, but even if they don't, the issue is more likelihood of confusion. If they have a mark that is out in commerce. So think of it this way. American Airlines does not have a registered trademark.
Okay.
Right. But you couldn't call yourself American Airlines because that would cause confusion. They have a common law understanding that, when we're talking about airlines and we're talking about this and American Airlines, they do have a trademark. They just don't have a registered trademark. So,
Okay.
yeah. And I hope that answered your question. I'm sorry. I might have got a little sidetracked there.
Crystal clear, man. That was awesome. Now, again, we keep giving you curveballs, but let's say Matt's got this idea of making toys. Now he starts making toys of American airline planes for little children, but he's using the American Airlines logo and the likeness. Does he have to contact American Airlines for some sort of license, or can he just go out and use it because it's in the public domain?
No, so I didn't mean to say that they're in the public domain. They just don't have a federally registered trademark.
Okay.
They rely on the common law trademark law. So if you look at American Airlines, if you ever see, they have that little TM, and that's saying, hey, this is our trademark, but they don't have the R with the circle, which means it's not registered. And the reason why American Airlines probably doesn't have a registered trademark is because it's American Airlines. That is literally describing what they are. So if you have a merely descriptive, so you're saying advisory group,
stock at the supplier,
you would not be able.
It's really just
to
how long does it take to put that thing into
onto
a railroad or onto a truck
group,
and get it across the country to your warehouse.
Exactly what you're doing,
typically
and what services you
right?
offer.
If you're buying from China,
you can't pull those words out of the lexicon because then that would mean no other advisory group out there could use the term advisory.
We really optimize across those two components.
Same thing with American Airlines. I'm sorry.
Gotcha. How about the term patent pending? I mean, obviously, it seems like a logical definition, but does that carry weight when someone else is looking to maybe promote the same sort of product or invention?
So that one is always the one I get asked. No, not really. There's no power, true power. Every now and then, patent pending might help you in the future of saying, hey, these people were put on notice, and they knew my idea was out there and it might be patented. That might go to willfulness. But at the end of the day, you really have no rights until a patent issues, because you can file a patent on anything. So you could just say anything's patent pending because all you got to do is pay the fee, file the application, even if you know it's never going to be allowed. So if there was actual force in patent pending, these people would just file patents all the time. And it would just say, hey, I'm covered. You can't do what I'm doing, even though they have no patent approved.
So what I'm getting here is trademarks are logos, images, words, right? And patents are inventions, things that we use every day, more physical products.
Yes, your utility patent. Now, there's a second type of patent called a design patent. And I tell people who are, if you're putting a product on market, you might as well get a design patent on it. It's a couple thousand. I mean, it's probably about $5,000, but it protects, especially if you're having molds. Say you have, design patent covers the way something looks. That's pretty much it. So what I tell people, say you are manufacturing overseas and you spend all these money on these molds, but guess what? The old, saying was, the company works for you for 8 hours and your competitors for 16 using your molds, right? So you can use design patents, like in the United States, saying, well, this is what my mold makes, and this is the design that comes out of it. So you can actually kind of, have a design patent that would prevent things that were using your molds from coming into the United States.
Okay, so let's talk about that for a second, because that's the elephant in the room when everybody, let's just say it, China, you go to China, your products get ripped off, right?
Yep.
What real recourse do you have to go after them, right? Because if you have a product that's selling well, every factory out there is now pumping it up, and they're your biggest competitors if you're on e-com in Amazon, right?
Right.
So what's the real recourse? Is there anything? Do they really actually even ever stop? Is it just you're taking that risk and you got to bake it into, your projections when you're actually starting the company?
Right. So theoretically, the easy thing would be is, say you have a U.S. patent, you can stop the importation of these items coming into the country. Therefore, you're protected that way. But they're still making it in China. So basically, when I have discussions with my clients, I'm like, where do you think this thing's going to be made? And if they think it's going to be made in China, I'm saying, let's file a patent application in China. The patent system isn't great over there, but it's better than it used to be. And you might be able to nip that in the bud, because what I always say is that, he who controls the manufacturing controls the universe. So if you can control the manufacturing centers, you don't have to go out and get that patent in the EU, because the EU is super expensive, very draconian, huge pain. I don't like dealing with them. But say you control the manufacturing center. Someone can make it in Europe, but they'll never make it as cheap as you can sell it in Europe if you have control over it in, say, China or Vietnam or India, wherever your product's being made.
So control the supply.
Yes.
Right. Let's talk about cost for a second. When you're a startup, you have an idea, you're doing all your money's going into R&D to see if you can get this thing to even work, right? Before you even get to the manufacturer. How much should people earmark when they're starting their company for trademarks and patents? And what's the cost and the timeline to actually get done?
Right. So the trademarks are pretty easy. I mean, generally, if there's no issue and there's only one class, and by class, we're asking about, someone who makes shields and someone who's an advisory group. Those are different classes. So if your product falls in one class, trademark, you're generally, and there's no issue, you're generally looking around $1,500. If there's issues that arise from that, then, we'll have to go from there. As for the patent, that can vary greatly. What I tell them, to get it to the patent office with the prior art search, you're generally looking between $6,500 to $9,000. That includes the prior art search and the preparation of the application and filing it with the USPTO. Now, understand, working with startups, I'm sure you dealt with lawyers before. Lawyers can tell you how to do everything perfectly, run your business, but then you have no money to do anything else, right? Right. So, and when cash is king,
I'm so happy you said that.
It came from the horse's mouth.
I know.
I know. I mean, I'm always like, my official suggestion is we got to pay for this, 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 and this. But I'm like, my logical suggestion is, maybe we should hold back on this, or, strategically invest your legal budget on certain things instead of, don't let perfect be the enemy of good, because it will. I mean, we got to file everything. We got to do these letters. We got to write so much stuff. And I'm like, let's try to get your business off the ground.
So, Austin, if you're a global brand, because so far our conversation has been focused on U.S. patents protecting U.S. products, goods, services, ideas. But if you're a global brand and you're selling your products in the EU, in Asia, in Africa, what sort of legal regime do you have to respect to have your product protected everywhere?
Well, that's the thing. So, I mean, there's a process. So very large companies, global countries, they use this avenue called the PCT application. It's the Patent Cooperation Treaty. And basically what it is it allows you to file an application, which kind of goes out globally, but it's not really an application. It's merely a placeholder. So you file it, and then it shoots a placeholder to the United States, China, and then all over the world, basically. I mean, there's some countries that aren't a party to it, but most of the ones you care about are. And then it gives you 30 months to file in every country that you want that's inside the PCT system.
So you physically have to file that patent in all the countries you're doing business in?
Yes. So, and then you have to find local counsel. You have to get it translated. Yes, that's why that's a heavy lift. Yeah, it's a ton of work. I mean, the ones who really, go everywhere are the pharmaceutical countries. And they already have their network of attorneys in this. And it's just, boom, they just, like a machine. But, for smaller entities or, that are looking globally and are thinking about, so I always say, if you're looking at 3 or more countries, we should go the PCT route, just because the amount of time that it affords. It also, another attractive thing about the PCT is that there will be an examiner who looks at your claims, examines it, and then gives you a preliminary report. If that report comes out positive, PCT is a great way to attract investment in your idea because you're saying, hey, a competent authority says this is likely to be patented. 2, we now have the ability to file all around the world because that may be something your investors are really looking for. They might not just be looking for the United States.
Now, during that 30-month period, does it stop anybody else from filing that patent?
No, it doesn't, but your place in line is set. So it's all about your filing date. So it's treated as if you've filed in the United States, China, EU, all the same day.
Okay.
In a scenario where the patent is filed, is that patent good in perpetuity, or is there a time frame?
Oh, yes. So in the United States and most countries, patents are valid 20 years from the date of filing, unless there were some extenuating circumstances where they will add some time at the end.
So can we talk about that for a second? Because earlier we mentioned public domain, right?
Okay.
Now, I learned about this a few years ago, and it's actually insane. So can
and
you
how
talk a little
much
bit about public domain and
how
when
much
something falls
intellectual
out of patent, it
property
goes into there?
has been
And then what
stolen,
people are
not just
doing
from
to
America, but
capitalize
from
on
every
that,
country
because
in
I
the
think it's
world
amazing.
that's gone to China and say, hey, set up
look
my
at
shop,
generic
right?
drug companies. They're
That
literally ready
if you're
to
going
go
run a
as soon as
business in
that
China, it
patent
has to be
expires,
51% owned
right?
by
They've got the
a
manufacturing
Chinese
facility.
entity.
They're
Well,
just
hold
ready
on,
to go.
right? Like,
so there are several ways that your patent goes into the public domain. Say your invention. The one that affects a lot of people that I deal with is that they disclose it too much. So before they even file for a patent application, you're excited. It's like your baby. You're like, hey, look at my baby. Or put up pictures on Facebook. They're like, look at my baby. And they're like, don't do that. That kills patent. Disclosures kills patents. The United States is actually kind in the fact that they give you 1 year from your first public disclosure to file a patent application. But that public disclosure will kill you in the EU generally and China and all these other places. So as soon as you publicly disclose it in those countries, it's public domain.
Mhm.
So if it's not covered by a patent application and you disclose it, those countries, public domain. In the United States, you disclose it, don't file within a year, public domain. You have given it to the public.
Okay, so if you are the owner of this patent, it would behoove you to be a capitalist maniac for those 20 years, because with 20 years in a day, it's open market, right?
Yes. Yeah. I mean, that's kind of your big deal. You hope that by that time you've built up enough brand recognition, all this other kind of stuff. I mean, but you and I both know a lot of these companies, they come up with their own knockoffs well before the patent expires.
Okay, how about those scenarios where you hear like artwork and whether it's music or cartoons enter the public domain? So let's say Disney has one of their characters is protected, but then suddenly enters the public domain and you see these T-shirts and ancillary products all over the place. How does that work?
Well, that one's tough. So there's always been the rule of parody. You're allowed to kind of make fun of copyrighted items. And just be fully honest, I don't deal with copyrights very much. Those are mainly entertainment lawyers. Okay. But, take Mickey Mouse, the original Mickey Mouse, I think the Steamboat Willie, correct me if I'm wrong, don't hold me to it, came into the public domain. So people are now allowed to put it out there because what it was 90 years. They kept extending it. And it was basically Disney that kept, funding Congress, like, let's extend the copyright. Let's extend the copyright. Let's extend the copyright. And this last time, I think Congress we're not doing this again.
Is it possible
so it was 90 years plus the life of the creator. So it's one of the things that software companies are known to do. They have these phenoms that are like 14 years old, and they write like one line of code on some software program. Therefore, they have 90 years plus the life of the, longest living inventor. One of the things, trademarks, is pretty interesting. So out in California, there was this famous brand back in the 60s or 70s called Noggles, and it was a Mexican food brand. And I think Taco Bell bought them eventually, but they never used it. And you cannot maintain a trademark unless you're actually using it. So some people came out and literally opened up a Noggles. It looks just like the old ones, has the same food, same menu, everything. Taco Bell complained, and the court was pretty quick to say, well, you haven't used it in 10 years, 15 years. You can't maintain it. that trademark is now within the public domain and someone else can now pick it up.
Now,
How
can
about
you?
colors? Are there protections for colors? Because there are some distinct colors in marketing. For example, the Tiffany blue or the Hermes orange. Can you protect the color?
Yep. And the red on women's shoes, I think, is another one. Yes, you can protect it because it's an identification of a source of goods.
Okay.
You go to a jewelry store or you looking at jewelry, you see that blue box, you know where it came from. You don't even have to look at the label. So if anyone were to come out with the same color box, that would totally,
confuse the
lead to
market.
likelihood of confusion.
Is that the rule of thumb to not confuse the market, or is it more a protectionist type rule?
Well, the intent of trademark is supposed to make commerce move faster. So
Okay.
we always have buyer beware. But if we're not allowed to trust companies, we would have to research every single one of our purchases. So that's what the trademark is for, is to enable commerce to move faster, protect customers from knockoffs. Yeah.
How does it work with technology, right? Because I would imagine there's certain advantages to having everyone access certain technology. So do they just license new technology? And that could go for, I don't know, LED. Like when the LED screens came out, suddenly you saw every manufacturer was making LED screens, right? Are those licensing agreements?
It's likely a licensing agreement, or they came out with their own technology.
Understood.
So the LEDs is either licensing. A lot of times, though, I worked with a large company that was based out of Taiwan, but had a huge presence in China. And it was kind of one, they were the OEMs. It was basically like the TV companies went to them and said, "Can you make me this TV?" They're like, "Sure, we'll just slap your name on it." But it's the same TV.
Gotcha.
Yeah.
I don't know if this question has any sort of breadth to it at all, or if it's totally misapplied, but does AI play a role in IP today? Like, can it be used? Because I'm trying to think, and a patent has to be novel or useful, but if AI is merely tapping into the public domain, can AI be used to come up with something novel and useful?
Well, according to the courts right now, AI cannot be the primary inventor of a patent application because the law is clear. The individual, that's who they grant patents to. I don't know how long that will last. And I've already been asked already, and it's getting to things like, "Hey, I had AI write this patent application for me. Can you submit it?" And I'm like, "Sorry, I can't." End up would take me longer to correct it or do what I need to do to it. But my big concern with AI is that, they say it's closed or you're paying for this model that doesn't learn from what you're doing. But most people are just throwing it into ChatGPT. And I'm like, we haven't made the determination yet. I don't want to be the first one who sticks my head out, but that may be public disclosure because at the end of the day, you've given it all this information on your idea to the biggest brain source in the world. And now it's incorporated it. That, to me, that's public disclosure. I don't know what the courts are going to say. I'll wait until they make that decision as above my pay grade. But right now, I'm cautious. I don't use AI. I tell my clients not to throw in their idea on AI. We can do searching and stuff like that, but don't throw in like the nuts and bolts and the secret sauce of your idea into AI because you've now disclosed it, in my view.
I have a question, and it's not technology wise, right? But we talked about copyrights, we talked about trademarks, we talked about patents. I don't know, since I was a little kid, I heard about Coca-Cola's secret recipe that they have in a vault. Is there any
Yep.
way to that? Or is
Yeah.
it a trade secret? Are trade secrets classified differently than these other ones?
Yeah. So trade secrets, there's not something that you get, it's not granted by the government.
Okay.
So it's basically that you've shown that you've done all these steps to keep something secret. And then if someone tries to expose it, you can get a court to tell them they can't, or they can't bring it to a new company. But, when I work with customers or clients with that, we go through the standard procedures. We basically have you need to pull this, you need to keep this out of the hands of these people. You can't let everyone know, the whole picture, those kind of things. It's kind of the only real IP that software companies can really have at this time. I mean, they can have trademarks and copyrights.
Used to
but
work
when you're
for
talking about the real
global company, and he set up their financing arm,
it's their,
and he set up banks in 7 different countries around the
only
world.
way to protect that is
they were trying to set one up in
what?
Brazil, and the challenge in Brazil was like their banking laws were so different.
Alice, just like Alice in Wonderland, it has destroyed software patents. It has took a huge sledgehammer to medical diagnostic equipment. I mean, it has just, it's decimated. So basically, what I tell people is, if your idea is taking information from a generic sensor, comparing it in a computer to a database, spitting out an answer, it's not going to be patentable.
So I have another question, and this goes to, I'm a CEP, I'm a certified exit planner too, right? How do we put a value on a patent or a trademark when we're going to exit a company?
There are people who do that. Not me. Well, you've seen it then. I mean, whatever that line that says goodwill, that's generally the value of the trademark.
Yeah.
Right. I mean, of the company, because it's all based upon your branding and this and your ability to protect it.
Or also your ability to scale, market, and exploit that patent in whatever time frame is left.
So many years ago, when I was working on Wall Street in the investment bank, we were pitched a deal from an attorney. He was going around, he was buying IP. And you know what he was doing once he bought the IP? He was suing other companies.
Oh,
once he had the IP. He was a patent troll. Right?
Oh, is that the term, a patent troll?
Yes. It's patent troll is basically someone who owns patents and never intends to manufacture them, only for the intent to license and sue.
That's a noble profession.
Well, I go back and forth on it. I mean, like, at the end of the day, this is property. And, he spent money on it. It could just be a dud. It could be nothing.
Sure.
I mean, wasn't it BlackBerry that got totally wiped out because of a patent troll?
Yep.
But what this company did was they bought all these defunct IP portfolios from the internet boom bankruptcies.
Yeah.
Right. So they invested. I mean, these are property. These companies got investment based on patents. So, I mean, there's value there. So I go back and forth, and I don't believe that you'll ever truly be able to get rid of patent trolls. I know they've kind of tried, but at the end of the day, it's a property right. And it's kind of like, hey, I just happen to have a piece of land next to a transformer or a substation now. You want to build your AI computers there now. This thing was worth nothing. Now it's worth a ton. That's the investment that they make.
I'm not against that either. Because you're going out, you're buying an undervalued asset for pennies on the dollar, and then maybe it doesn't do something, and then maybe somebody finds a way to do it, but you got there first. So it's exactly like it's like having the land rights.
Think about what Austin said earlier. The purpose of intellectual property and protecting intellectual property is to promote commerce and to promote sciences. If your sole purpose is to use it as a shield and not a sword, I don't know. I think you're kind of hurting like the noble intentions of intellectual property. Again, this is me being the idealist.
Yeah, but I mean these large tech companies, right? They've actually gone out and acquired companies just for their patents.
Sure.
Right? To protect themselves from what they were already developing.
Well, I mean, that's why it's limited in time. It's just 20 years. Sure. Yeah. I know 20 years is a long time, but at the end of the day, I mean, look what we've seen in our lifetime, right? I mean, those space rockets are going to be in the public domain before too long.
20 years is not as long as you think.
Right. Especially when you're looking at, ramping up a product production and all this kind of stuff. I mean, especially if you're looking at pharmaceuticals, I mean, they get the patents on them. And, I'm not well versed in the patent pharmaceutical fields. I think they can get some kind of extensions through the FDA and stuff. But
do they have 20 years, or is it a shorter lifespan?
No, every patent is 20 years, except the design patents. The design patents, I think, are 14 or 17. I think it's 14.
What the guy that ran for president, Vivek, that was his business, right? As soon as something came off patent, they would make the generic version of the drug, and they would sell it. So that's a huge business.
Yes, there's huge, and the big issue with the pharmaceutical I think the guy was brought up on Congress, and I forgot exactly which drug it was, but take Botox, right?
Hmm.
What was it developed for? My understanding originally it was developed for people with sweaty palms.
Okay.
Right. And sweaty armpits. They started doing that, and then they started seeing all these wrinkles go away. So they file another patent for it to treat wrinkles.
Okay, so here's a question for you. So let's say that was developed for sweaty palms, right? Luigi's company developed it. But I figured, you know what? My wrinkles are going away. Can I go and file a patent for a different use case?
Yes. So, but the issue is if he had a patent on the underlying product, then you couldn't make that product.
Okay, gotcha.
But take Botox, right?
But
Botox,
but what if
botulism has been around forever, right?
Mhm.
So
Yeah.
they're just bottling Botox.
Man, you better have a sweaty forehead if you start taking away my wrinkles, man.
Well, I mean, if you look at it right now, you have Ozempic, which is the brand name, right? But
Right.
it's a compound of semaglutide, right? So semaglutide, they add in a little B12 in that semaglutide. They can sell it not as Ozempic, but the basis of what it is, right? Semaglutide with B12 is a compounding thing. That's why a lot of these compounding pharmacies have been making money with it recently.
Yeah, I'm not super familiar with that. The only patents I really don't touch is like pharmaceutical products and heavy duty chemistry. That is, I barely made it through chemistry, so I don't want to see
So
that stuff
Austin,
ever
these
again.
examiners at the PTO, they've got to be probably the sharpest people in government.
Next question. I'm kidding. No, I used to work there. And it's just, no, it's honestly, there are examiners that are, I mean, they tore me up, but it was good that they did. I mean,
Wasn't Einstein an examiner?
Yes. Yeah, he was. And I'm sure he was very good at it. But I mean, the thing is it's a research job. It's a job that lends itself to a very, select skill set, because it's close the door, look at a computer, or what we used to do is go through the shoes, which were the physical patents, for hours. And you either have the ability to do that or you don't. But, understand, while there's one patent office, there's really like 9,000, I think, 10,000 patent examiners, and each one of them their own little patent office. So you can't have that many people. You're gonna have the gambit. You're gonna have people that you are just, I can't believe I'm dealing with this person, and then others you're like, wow, this person nails it.
We're lucky we got this guy.
Yeah, exactly. No. Okay, look, some of the best ones. There are patent examiners who take pride in the fact that they don't allow anything.
Okay.
Wow.
And yeah, some people, I mean, and it can become obtuse because your client has limited funds. And
listen,
you might be right, but they're just like, we take pride in being, the
How
stingiest
far can you
examiner.
take that battle? I got it.
So listen, we know that way too well. We deal with a lot of funding for clients of ours, right? And there are underwriters that take pride in just not letting anything get by. So it's kind of the same issue.
Right. How many times can you start, climbing up this tree? It's greased, you're just never going to get to the top. And you might eventually win, but it's 20 years from the date of filing.
Wow.
So if you spend 5 years, 6 years arguing with the examiner, you've lost a good portion of the value of your patent.
So Austin, thank you so much for being here. We want to be respectful of your time. Why don't you tell the audience? I mean, you gave us so much. I'm sure people are going to be reaching out, how they can get in touch with you on the socials, through your website. How can they find you?
So I actually, I post a lot of videos on Instagram, TikTok, all this stuff. Austin, the patent attorney, you can easily find. Just look up Bonderer, Bonderer, patent attorney, and you will find me. Luckily enough, I'm the only one I really know with that last name besides my family. So yeah, pretty easy to find.
Thank you so much. And I do have one question before we let you run. What is the weirdest thing somebody came to you to patent?
Oh man, that's I wouldn't say there was nothing that I did personally. When I was at the patent office, someone in my art unit, someone came in with a method of cutting hair.
Okay.
Now understand, they have to give you a patent if they can't find prior art. But some things are so far out there even though it makes like, I know how to do this, there's just nothing written about it because no one thought it was important enough to write about or exploit or anything like this. And I think it got allowed, and then there was an uproar. The office pulled it back, and they eventually had to use Edward Scissorhands as prior art to invalidate the patent.
Oh my God.
Yeah.
I'm just trying to. So, what does that consist of? A method of cutting hair? Put the scissor in your right hand, put it in your left hand, twirl around a couple times.
Yeah, but where's a patent examiner going to find something like that? You know, it goes somewhere. I mean, we're all looking at like technical things that people want to really make money off of. So they're going to spend the time on, you know, because it costs money to file a patent application.
Yeah.
I think there was another one time where there was an attorney, he had a kid, his kid, he was a patent attorney. He was like, come up with something. And the kid came out and was like, Dad, I found a new way to swing a swing. It was like side to side or something like this. And I mean, it actually started to go through because they couldn't find prior art, even though, because you got to find something printed or, you know, some kind of physical evidence that this was known. Some things you just can't find that evidence for, even though you know it's the silliest thing out there.
That's awesome.
Yeah.
Austin, thank you so much. Everybody, that's a wrap for the Liquid Launch Project. We'll catch you on the next episode.
Thanks, guys.
Let's go!